From the opinion pages of the Wall Street Journal, this is Potomac Watch.
As the Supreme Court prepares to consider whether Congress can ban Chinese ownership of TikTok in the U.S., President Trump weighs in by filing an unusual friend of the court brief with the justices. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Alicia Finley and editorial board member Monet Ukwe-Barua. The social media app TikTok reportedly has something like 170 million monthly users in the United States. And after years of debate about how the country should handle the risk of that, things are now moving rather quickly, it seems. Last spring, Congress passed a law called the Foreign Adversary Controlled Applications Act, which says that TikTok would have to be divested from Chinese control or else it would be banned from phone app stores in the United States. That was challenged, and on December 6th, the appeals court for the District of Columbia Circuit upheld it in a unanimous panel ruling. The Supreme Court then on December 18th said that it would take up the case on an expedited basis, oral arguments coming on January 10th or next Friday. And then over the weekend, on Friday, last Friday, President Trump weighed in with a brief of his own arguing for some kind of stay to kick this decision into his next administration, since the current deadline is January 19th. That's one day before his second inauguration. Alicia, maybe the place to start is with what the District of Columbia Circuit said and why it went about upholding the law, this foreign adversary app law passed by Congress.
So TikTok argues that the law violates its own free speech rights. And there's a separate argument by users in this case that the ban, or let's not call it a ban, it's basically an ultimatum that would allow TikTok to divest from its Chinese owners ByteDance or be banned. But TikTok argues that this violates its speech rights because it actually has editorial discretion to manipulate the algorithms. I guess that's not putting it very nicely, but basically control and edit or curate how content and posts appear on the platform. And now the Supreme Court essentially ruled in NetChoice decision over the summer v. Texas that editorial discretion platforms, how they curate content algorithms, are protected by the First Amendment. Now, the D.C. Circuit, it actually did consider this First Amendment argument. It didn't dismiss it out of hand. It actually considered it under a very high level, under strict scrutiny. But nonetheless, it found that the government had shown a very compelling interest, and that this was a very narrowly tailored in the least restricted manner possible to address the government's concerns. And the government's concerns are namely national security, one that TikTok would be sharing data about American users with ByteDance, its Chinese owners, and this essentially would be fed back to Beijing and the government officials who would be able to surveil Americans. Now, the second concern, national security concern that Congress had, was that the ByteDance engineers who do control the algorithms would manipulate them to promote politically favored content by Beijing and politically disfavored content. And there was a lot of evidence in the record that it was already doing this, and notably TikTok didn't deny it.
I'll read a couple of lines on those two threats cited by the government from the ruling. This is from D.C. Circuit Judge Douglas Ginsburg. First, on the point about the data vulnerability, he says 2 consecutive presidents understandably identified TikTok as a significant vulnerability even after extended negotiations. TikTok could not satisfactorily resolve the government's concerns. And then on the point about the potential for TikTok to be used to manipulate public opinion. Again, here is from the ruling by Judge Ginsburg. Notably, TikTok never squarely denies that it has ever manipulated content on the TikTok platform at the direction of the People's Republic of China. Its silence on this point is striking, given that the intelligence community's concern is grounded in the actions ByteDance and TikTok have already taken overseas. A couple other thoughts I would add in here, Monet. One is that the opinion also references similar laws in terms of like broadcast media. There are rules around foreign ownership of radio stations, TV stations, things like that, that have been upheld. And two, this is not an attempt by Congress to micromanage any sort of specific content decisions by TikTok. And I think that's key too, because laws that are content-based are given a very hard look by the judiciary. And the point here is that Congress is not saying we're going to demand that TikTok censor certain content or not censor certain content. It's not saying that at all. It's just saying that those decisions have to be made by employees who are not ultimately answerable and under the control of the Chinese Communist government.
Exactly. I think that TikTok tried to blur those distinctions that you and that the DC Circuit made in their ruling by claiming that the act of Congress giving them this ultimatum to sell or be banned was essentially depriving them of their free speech rights as distributors of content. They actually mobilized their very large army of influencers who use the platform to reach millions of people to come in and say that our voices are being suppressed by President Biden and by the federal government. We're no longer going to be able to reach you, our audience, with the messages we want to get across. They basically tried to pull off a PR campaign and a legal campaign to suggest that they were being censored. And I think that the judges who ruled on the DC Circuit did a very good job of saying that this has nothing to do with the content being expressed through the app, that individuals still have just as much right to say everything that they want to say, and that there is no threat in the law against that manner of expression. And even the Chinese government has the ability to express whatever messages it wants to express. The issue is, are they able to control a platform of this scale? Because that, as you mentioned, has national security and privacy concerns. And so trying to balance the interests of creators of these platforms to be able to continue to express messages with saying that a platform of this scale shouldn't be in the hands of a foreign adversary, they decided that the act meets that standard of being tailored to meet the specific concerns that the government has. And I think, interestingly enough, President Trump endorsed exactly that perspective when he first attempted to force TikTok to sell off its American business during his own administration. And he, for a variety of reasons, has walked back that position somewhat. But I do think it's interesting that in the brief that he filed, or that his soon-to-be Solicitor General submitted to the Supreme Court asking them to delay their decision, it explicitly didn't take issue with any of the merits of the DC Circuit's ruling. He basically was suggesting that there might be an opportunity to come to a deal that would be more favorable to the American people and to TikTok. But on the merits of the ruling, in terms of whether the government is able to actually bar TikTok from operating a U.S.-based business, Trump made no objection.
Hang tight. We'll be right back in a moment. Welcome back. Alicia, were you surprised by the Supreme Court's decision to take this case in the first place? Because a couple notable things about this three-judge panel at the D.C. Circuit. One is that it was cross-ideological. The opinion was written by a Reagan appointee, joined in the outcome by an Obama appointee and a Trump nominee, and also a lot of judicial firepower there. So Douglas Ginsburg, the writer of the opinion, was nominated briefly by Ronald Reagan to the Supreme Court back in the 80s before withdrawing after controversy about past marijuana use. The judge who's the Obama appointee, Sri Srinivasan, often discussed as a potential Democratic nominee to the Supreme Court possibly in the future. And ditto for the Trump appointee, Judge Naomi Rao. Some thought that she might be on a short list for a future Republican president. And so the unanimity of the opinion by this very ideologically broad panel of DC Circuit judges, I mean, are you surprised that the Supreme Court decided it wanted to get involved here instead of just letting that opinion stand?
Well, I think there are a couple of reasons they may have decided to take up the appeal. One, it's an incredibly important case politically, and so it may want to have the final word on this. Second, the law also allows a president to use his powers to restrict other apps that are controlled by a foreign adversary, namely China. So the same law could be used to potentially ban or force divestment of another Chinese app the president deems it presents a national security risk after going through certain procedures. So the court may have wanted to settle the question in case future challenges to the president's exercise of this authority comes up, and just to head it off right now.
That's an interesting point because, Monet, if the justices had let the D.C. Circuit opinion stand, then a future controversy over whether this is constitutional in the first place, a future app that is controlled by a U.S. adversary may have an opportunity to litigate that up to the Supreme Court if the Supreme Court didn't settle it now. It seems to me that my instinct is that the Supreme Court will be on the side of backing up the D.C. Circuit here and saying that this divestment requirement is constitutional. But it does seem like there are some questions on which the justices think they are big enough that they ought to have the final word and not leaving it to the appeals courts.
I think that that's right. There isn't any example to point to from the Roberts Court of a kind of free speech absolutism that would militate in the direction of saying that China must be allowed to operate a giant influential app on American soil. I think if you look at the concurrence that Sri Srinivasan wrote in the DC Circuit opinion, he mentioned that they decided from the outset to consider the case under the strictest level of scrutiny, which basically conceded that China did have a certain amount of free speech rights, or rather that TikTok did, and that there should be a very important reason why the government would need to intervene in order to bar the app. But Srinivasan pointed out, because TikTok is a foreign company, it actually isn't necessarily entitled to the highest level of scrutiny. It's possible that the barring of TikTok's U.S. business could have been upheld on an intermediate scrutiny basis. And so there's very little in the merits of TikTok's legal argument that put before the Roberts Court, which tends to take national security very seriously, would entice them to reverse the DC Circuit's opinion. I do think that Alicia's right. It's merely the high stakes of the case, the fact that it's such an important one and one that is going to set a precedent for a lot of future conflicts in this country because of the growth of social media, that they wanted to be able to put their stamp on it and affirm it rather than reconsider the arguments that were made in the DC Circuit level.
Then what about Trump's decision to jump into this controversy? Listeners may recall that he was skeptical of TikTok during his first term, had plans to ban it unless some kind of divestment agreement could be come to. In recent years, he has been more sympathetic to that. This is Trump on Truth Social before the election in September 24.
For all of those that want to save TikTok in America, vote for Trump. The other side's closing it up. But I'm now a big star on TikTok. We even have TikTok Jack, and we're setting records. We're not doing anything with TikTok, but the other side's going to close it up. So if you like TikTok, go out and vote for Trump. If you don't care about TikTok and other things like safety, security, and prosperity, then you can vote for a Marxist who's going to destroy our country. Thank you very much.
And now he's jumped into this legal debate with this brief, though, Alicia, to my eye, there is less law than politics in this amicus brief filed on behalf of President-elect Trump. What did you make of the arguments that he is putting to the justices?
Well, if you recall, actually, back in last spring, he also posed the ultimatum because he thought it would benefit Meta, in part, like if fewer people could use TikTok, they would go to Meta, Instagram, or Facebook. I don't think that that's necessarily true. But now in his brief, he argues actually that he has unique standing to represent the some 170 million TikTok users because he is a maestro at social media and just look at Truth Social. It's a kind of a mix of puffery and legal sophistry, but he actually implies in this brief, interestingly, that he won the election in part because his very adept use of TikTok and social media. I don't think there's actually evidence of that, and I think it's interesting that he's now making that argument. My supposition is that somebody who doesn't want TikTok to be banned has whispered that in his ear. Perhaps it's a donor who's invested in ByteDance or such, and that is the reason he is now coming out against this. In the Trump world, all politics are kind of personal. And so his argument in the brief is that just give him a little bit of time and he can save TikTok. He can negotiate some kind of deal that would have to require Congress reversing the law, which I don't see happening given that how strong of support it had. It passed with 70-80% of members in both chambers. But he claims just give him some time and he will save TikTok.